don't have a lot of money. Do I really need an estate plan? Hi, I'm Alec Osland, an attorney at Yanowitz Law Firm, where we've been helping families for 30 years with wills, trusts, and probate. Now, the question of do I really need an estate plan? I don't have a lot of money. I don't have a lot of assets. Is it really necessary? That's a common question that we hear in the estate planning world. My general answer is, well, do you want to leave a mess to your family? Do you want to leave no direction? Do you like things being chaotic? Do you like additional expenses? Is generally kind of my answer to that. Not to mention, if we have minor children, then it's even going to get even more complicated. So the answer is always yes, yes, yes. Even if you don't have a large amount of assets, you should still have an estate plan. Generally speaking, one of the biggest drives to have an estate plan is to name guardians for minor children. So if you have minor children, it is your parental duty to make sure that there is a spot and a proposed guardian for if something does happen to you. You want to have a say with who takes guardianship of your children if something were to happen to you. If you don't, then we're going to be relying on a court to make that determination without any of your input, and it could definitely cause some stress in the family. The person that you would want to be guardian may not be appointed by a judge. So yes, it is very important that if you have minor children, that you have an estate plan, especially a will that nominates who should be guardian if something were to happen to you. Regarding assets, yes, it is important to, even if you don't have a large amount, that you have what happens with those assets in your estate plan, especially again if you have minor children. The law is set up that for an 18-year-old to inherit everything, that would be, as part of the estate. And generally speaking, a lot of my clients don't want their 18-year-old child, or I guess at that point, 18-year-old adult, to inherit those assets. A lot of times we want to set up restrictions so that child maybe inherits half at 25 and then maybe the remainder at 30. Prior to that, we have a trustee who's in charge of, managing those assets for their health, education, maintenance, and support. And they have the fiduciary duty to that child to manage those assets accordingly. And once that child reaches maybe the age of 25 or 30 or 22, whatever it is, maybe at that point, that's when the assets would go to them and they can use them how they want. But generally, we don't want an 18-year-old to get their inheritance because they may not use the inheritance in an appropriate way. With that, we want to set up what that distribution looks like in your estate planning documents. If you have life insurance, not an asset that people generally think of when they think about the assets that they're leaving to their children, but you always want to remember if you have life insurance, it's generally pretty substantial. That's going to be a large amount of money going to your children. With that, we also want to think about who's going to be in charge of collecting all of these assets. Who do you want that person who going through your house, inventorying everything, going through financial accounts and seeing what there is. They're looking at past receipts. They're doing tax returns for the estate. Going to essentially kind of be doing very personal things for you. You probably want to pick who that person is. If we don't have that in our estate planning documents, then we're going to have to rely on Minnesota statutes when determining who is that personal representative. So because when we think about an estate plan, we do an estate plan for really two reasons. One is we want to identify where our assets are going when we pass away. And two, we want to identify who's in charge of making sure the assets end up there and has that fiduciary duty. If we want to pick how they're distributed and who's in charge, we want to make sure we have an estate plan. Part of an estate plan is also a healthcare directive. So if you're unable to make your medical decisions, we want to have a directive that appoints an agent to make decisions on your behalf. We don't want to have to rely on a judge to make a decision of who's acting for you. We want it to be your decision. And the only way to do that is if you have a healthcare directive. The same thing can be said about a power of attorney. If you're incapacitated, they can act for you even while you're alive and you have capacity, But the big thing is if you're incapacitated and unable to make decisions, they can help you out. And we don't have to rely on going in front of a judge and having a judge name a conservator of you to start handling your assets and helping you out. We can use that power of attorney to do that. It's really important that we have an estate plan, even if we don't have a large amount of assets in your estate. With estate plans, we don't have to have a large amount of money, but in general, if you want to help your family, if we're going to try to avoid probate, maybe that's a goal of it. But the big thing is, we're making it as seamless as we can, because it's going to be an emotional time when you pass away for your loved ones. So you want to, provide for your loved ones as much as you can by being organized and having a plan put in place. Also, again, we want to prepare for any medical conditions down the road, whether we know about them or not. So we want to have that healthcare directive executed, naming that agent. And then the power of attorney. If we become incapacitated in the future, we want to make sure we have a power of attorney that names who, again, is going to act for us, and we're not relying on a judge to make that decision. So if you're interested in finding more about estate planning, make sure you subscribe to our YouTube channel so you can find out when we post another video. Thank you. Bye.